National security is of utmost importance to any country in the world. Around the world, Hong Kong and Macau are the only local administrative regions which have been authorized to enact a national security law, according to the Basic Law, a constitutional document for the city. Unfortunately, the legislation was not in place for Hong Kong after 23 years, nearly half of the 50-year period, to which Hong Kong's high degree of autonomy was granted. The 6-month riots in 2019 demonstrated that the threat of national security in Hong Kong was no longer hypothetical and has caused serious threats to law and order as well as lives and properties in Hong Kong. Biased reporting by some media filled with violence, lies and rumors of protesters directed to the police force has brought this Asia's world city to a halt. It was under this background that the central government, through the National People's Congress, has enacted the National Security Law in Hong Kong under the power vested by the Basic Law. Hong Kong's law and order were quickly restored and people's livelihood were largely back to normal after its enactment on June 30th last year. The outstanding issue in Hong Kong right now is the fight against COVID-19, the progress of which has not been very satisfactory at all. As a think tank leader and a citizen brought up in Hong Kong, I feel obliged to present the real situation of Hong Kong to this council and address some misconceptions by the Western media and community towards the law. In the interest of time, I will pick a few most widely held misconceptions and respond one by one. First, are the cases adjudicated by mainland judges or hand-picked judges by the chief executive of the city? The answer is no. According to Article 44 of the law, the chief executive shall designate a number of existing judges to handle cases concerning offense endangering national security. So, all judges of NSL are existing judges, and more importantly, the assignment of a particular judge to adjudicate a particular case is solely determined by the judiciary, not the chief executive, nor anybody in Hong Kong or Beijing. The second widely held misconception is that suspects are being sent back to mainland of China for trial in an arbitrary manner. Of course, the answer is no. Article 55 of the law states clearly that only under exceptional conditions would the Office for Safeguarding National Security of the central government exercise jurisdiction over a case, including if the case is complex due to foreign country involvement, serious situation where the government is unable to enforce the law, or a major and imminent threat to national security has occurred. Opposition politicians and the Western media have cited the recent case of 12 youths fleeing Hong Kong as an example of human rights abuse in association with the law. This again reflects the bias of some media who tend to portray rioters as heroes or champions of democracy fighters. Come on, these people are criminals jumping bail, or what we call fugitives, and intercepted by Chinese coastal police. They are not the so-called political prisoners. The charges of these 12 criminals range from arson, possession of weapons and bomb-making materials, riots, and collusion with foreign countries to endanger national security. They have been subject to fair trial in Hong Kong, and no one forced them to flee to Taiwan. This case in fact highlighted the widespread concerns in Hong Kong that bail should not be granted so easily to offenders of national security law. The third misconception is whether the rule of law is dead in Hong Kong. Are judges under tremendous pressure in passing down judgments favorable to the central government? The answer is also no. I would like to draw attention to two articles of the Basic Law. Article 85 stipulates that the courts of Hong Kong shall exercise judicial power independently, free from any interference. Article 89 stipulates that Hong Kong judges may only be removed for inability to discharge his or her duties or for misbehavior. Simply put, Hong Kong judges could not be fired for handing down unpopular judgments. Judges do get criticized, as most people nowadays do in their public office, but they remain independent of political and other influences. In fact, the independence of Hong Kong judiciary has been reiterated by the former Chief Justice Geoffrey Ma. In his farewell speech and the press conference in January this year, he stressed that judicial independence and the interpretation of the Basic Law by the National People's Congress Standing Committee are not incompatible. Both are prescribed under the Basic Law. He also highlighted that no pressure has been exerted on him and the judges of Hong Kong in adjudicating cases. As one of the most respected figures in Hong Kong, the former Chief Justice's speech definitely carries much more weight and credibility than the opposition politicians or doomsayers in Hong Kong. And to date, we have seen nobody, including Martin Lee or other opposition politicians, challenging Justice Ma's above remarks. British Foreign Minister Dominic Raab said last week in this council that the security law is a breach of Sino-British Joint Declaration and is having a chilling effect on personal freedoms. This is simply unsubstantiated accusation. We must ask Mr. Raab, which clause of the Joint Declaration has China violated? Which clause of the NSL violate our human rights? What we have seen, on the contrary, is British government violating its own memorandum of the Joint Declaration and its own policy by granting BNO passport holders right of abode. Mr. Raab also commented on the elections in Hong Kong. While I have no interest in commenting the parliamentary democracy in the UK, nor the fairness of its winner-take-all voting system of MPs, I hope the British government would also leave it to Hong Kong people to develop our electoral system according to Basic Law. So, can we still protest in Hong Kong under the security law? The answer, of course, is yes. Hong Kong streets have been much calmer than before in the past year, mainly due to the social distancing measures for fighting COVID-19. 4-person gathering rule is now implemented, as in many European countries. Therefore, we should not mix up the strict anti-gathering rules with the NSL. Hong Kong's freedom of speech, assembly, and peaceful protests are not in any way affected. When our battle with COVID-19 is over, we will see protests again on issues like housing, social welfare, environmental sustainability, etc., in a peaceful manner. The only exceptions will be those who champion for independence, terrorist attacks, or sanctions to our officials, or those endangering national security. Yes, protesters will be deprived of this kind of freedom and rights, but it should never have been allowed in the first place. In the past year or so, we have seen the executive and the judiciary of Hong Kong discharging their responsibilities in accordance with the Basic Law. The judiciary has been dedicating its efforts in interpreting the law, which is a piece of continental law, in a way compatible to its common law tradition. A recent example concerns the interpretation of Article 42 of the law about the threshold of bail for defendants. The Court of Final Appeal, in the case of Jimmy Lai's bail application, indicated in February clearly that this provision is a specific exception of the general bailing regime. The judges also highlighted that the presumption of no bail was not something new, as they have cited examples in other common law jurisdictions, such as Canada, South Africa, or Australia, where it requires the accused person to establish why he or she should be on bail. In fact, many accusations on the implementation of the law are ungrounded, as to this date, no cases have been concluded and no accused persons are penalized. I would hope members of the international community and media will take a rational and objective approach in assessing the law and trust the independence of our common law judges. On a final note, as a researcher on one country, two systems principles and the Basic Law, I would like to stress that one country, two systems policy is still being fully and successfully implemented in Hong Kong. The essence of one country, two systems could be summed up in one sentence. Hong Kong should maintain a system which is different yet beneficial to China, our country. Beijing has never intended to turn Hong Kong into another Chinese city, as Hong Kong's unique system has provided huge benefits to China. China will be the first to suffer if Hong Kong becomes a socialist city. On the other hand, Chinese government, as in all governments in the world, would not tolerate any attempts of anyone to endanger its national security, to carry out terrorist attacks, or to seek independence in Hong Kong. I am confident that if people in Hong Kong and the rest of the world will bear this in mind, one country, two systems policy would survive and sustain well beyond 2047. Thank you.